Welcome back. So we are talking about matters BBI on judiciary. And just before we took a short commercial break, lawyer Kisinje, you wanted to respond to Steve Ogula's sentiment.
I think I wanted to respond to him so that he probably understands where that particular aspect of enhancing the judge's qualification is coming from. It's not about what he's talking about, but it's a question of these years that are proposed in the current BBI, if it goes through, years that were picked from negotiation. Negotiation being that judiciary was one of the institutions that was actually invited by the BBI and gave their proposals. So I'll assume that apart from the non-controversial Ombudsman office, I'll assume that the years of 20 for the Supreme Court, the years of 15 for Court of Appeal, and the years of 10 for High Court actually came from the institution itself. So this is what the institution demanded or asked for to be incorporated in the BBI proposal. So I do not think that BBI, the team of experts, just sat somewhere in a corner and came up with these years. They do not work in that institution, but these are proposals that came from the judiciary as an institution itself. So let that just be clarified.
Wakili, just hold on. I was about to ask you that, because if you read the JSC presentation and also the Chief Justice's presentation to the task force team when they're collecting sentiments from Kenya, at no point did I see this proposal that have been put in place by the task force being put forth by these two people. The office, the Judicial Service Commission, and also the office of the office of the Chief Justice.
The Ombudsman, I do not think that it came from the judiciary. That's controversial anyway, and in the sense that people are discussing and debating it. And I think we've overcome that decision on the Ombudsman. It's something that I think going forward, people will be keen to understand how do we insulate the judiciary from being compromised by the executive. That's a valid concern from any lawyer. So I don't think that anybody can argue on that. My issue is those years, enhancement of years, over and above the proposals that the judiciary gave. I am sure there was a one-on-one discussion between the Chief Justice, judiciary representatives, and the BBI. So I do not think, and I think Steve agrees with me, that the enhancement of the years is not a bad thing, it's good. I think his problem is there should have been a benchmark of how do you then enhance those years. But I don't think that the years enhancement and the issues of looking at quality of judgment, having seats on the judges sitting in those courts, I don't think it's a bad idea. It's a good idea. And we can still live with it. It's something that cannot kill an institution. So I don't think that we should spend so much time debating on why a Supreme Court judge should be 20 years. No, it's not disenfranchising anybody. That's the most bottom line about it. We should now focus on how do we enhance that issue of the Ombudsman and ensure that you insulate the judiciary from being compromised or perceived to be compromised. That's my clarification I'm just trying to say.
All right. Steve Ogula, Wakili, you look like you wanted to respond.
No, I think I can let that rest because I already admitted that in principle there is no problem with enhancing the durational experience of judges of any court, be it the High Court, the Court of Appeal, or the Supreme Court. I only added that if it is because, if the reason for enhancing the experience at the Supreme Court is because we are doubting the quality of their workmanship or their products, then we may also be careful as we enhance to also address the structural systemic problems within the judiciary that make judges susceptible to producing poor quality judgments. Is it the workload? Is it the workforce? Is it the administrative issues? So all these things must be exhaustively addressed because we may be proposing to enhance and then not solving the problem. And that problem could be shared also with the bar because it is the bar that feeds the judiciary. Judiciary doesn't hire from anywhere. Judiciary succeeds itself from within and also succeeds itself from the bar. Is there a comparing conversation that LSK is having to improve the quality of lawyering so that lawyers entering the judiciary is chosen from a pool of competent? If you have a pool of incompetent lawyers, you will have a pool of incompetent judges and so on and so forth, even if you enhance the experience to 30 years. But I think in principle it's not a bad thing. Let's just look at the issues, both structural, administrative, and competency-based challenges that mitigate against good work.
All right, and Wakili Kakai, let me bring you into, you know, what the BBI explains. It's good, it's also on our screen. And, you know, it says that the office holder, the person who's holding that office of the Ombudsman, will also be barred from investigating matters pending before court or tribunal.
What's your question?
My question is on the mandate of the Ombudsman, what the Office of the Ombudsman needs to do and what it doesn't need to do. And the BBI explains that the office holder will also be barred from investigating matters pending before any court or tribunal.
Yeah, and that's a basic understanding of how the law operates, is that you cannot be a judge in your own cause, meaning therefore that the Ombudsman, once a matter is before a court of law, then you sit, and that happens everywhere. Let the court of law come up with its own finding, let the matter be finalized before then you actually try to investigate. It's just enhancing issues of complementarity and issues of respecting institutions. So that's one of the things that probably is a good thing, in the sense that the Ombudsman will now not want to interfere with what's active before court. Even right now, for example, a matter that is being investigated, which is before a court and active, any other arm of government or any other institutions in government is not bound to look into it, because then it's assumed that that institution of the judiciary will come up with a comprehensive analysis of what's before it and render judgment. So I don't think that that's a big problem. That's a good thing, in the sense that leave the institutions to be independent to do what they're doing and don't interfere with what is before that institution. All right.
So lawyers, we need to wind up this discussion, so I'll give you a minute each to respond to my next question. So JSC and the Chief Justice presented their, memorandum, or actually their suggestions to the task force, and it was about the funding of the judiciary. That is the judicial fund. Let me start with Steve Ogola.
I read the Judicial Service Commission and the Chief Justice proposal to the BBI committee or task force, which was largely ignored. I think it was the central issue in their proposal was, how do we give the judiciary more funds? And how do we protect the judiciary from begging for money? And they proposed even as little as 3% of the national revenue. And they gave a breakdown of what they can do with such amount of money in terms of building courts, employing more judges, and so on and so forth. BBI neglected that central concern. And I think that's a bad thing, but there's an opportunity now to reinstate that. If you're going to make some changes relating to the judiciary, at least let us be respectful enough to recognize that this is an independent institution that can speak for itself. So do not expand the scope of what concerns the judiciary to include things that are not priority areas for the judiciary. Right now, the priority areas of the judiciary is that we should have more cases handled expeditiously. To clear the backlog, you need more judges, you need more courtrooms. And all these are a function of money. So can we then say that we are going to give an assurance to the judiciary that we will enhance their budget, make it accessible, and make it predictable? Right now, they have to wait longer, and projects that were stopped, actually, the CJ said, most of the judiciary infrastructural projects are being funded by donors. And it's a shame that an independent constitutional organ should rely on external financial support more than it can rely on its own government, on national resources. So if BBI wanted to improve the functional independence and accountability on the part of the judiciary, they should start by funding them properly and then asking them to be accountable.
All right. Wakili Kakai, in a minute, because we need to wind up.
For me, the biggest challenge that that institutional judiciary goes through is basically on the 2010 Constitution and the establishment of the Judiciary Fund. Now, I worked in that institution, and that's one of the things that once we sort it out, and I agree with Steve, once we sort it out, then it will be fine. Because what we did is that there's already a Judiciary Fund in place in terms of the Constitution. The judiciary went ahead and prepared the law that establishes the Judiciary Fund, which is called the Judiciary Funds Act. And then thereafter, there were legislations that were prepared in terms of enhancing how the Judiciary Fund operates. The whole idea of the Judiciary Fund was to give, and is supposed to give, financial autonomy to that institution. Because if you don't have financial autonomy, then you cannot operate independently and you cannot be in charge of your own money.
Right.
But then what has happened is that ever since the establishment of the Judiciary Fund, ever since the establishment of the Judiciary Fund Act and the regulations that support it, then the exchequer or the other arms of government have not been able to officiate to ensure that actually the judiciary operates like that, because the budget money is supposed to go to that fund. So I think the problem which is there is the judiciary must continue pushing to ensure that the judiciary fund is in place and is functional. That's the only thing that will guarantee extra and independent autonomy, and that is a valid concern in my view.
All right, gentlemen, thank you so much. Legal minds right there. Steve Ogola, who's a lawyer, and Kakai Kisinja, also a lawyer, talking to us about BBI on judiciary, bringing us to the end of this discussion today on BBI explanation.